If he does not have funds to pay off the judgment, then we will seek judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
Trump was held liable for exaggerating his wealth and inflating the value of his real estate so banks would give him low-interest loans. Trump insisted the banks liked doing business with him.
They said no victim, no one got harmed, the banks got paid back. So no harm, no foul. Why is that not the case in your view?
So financial frauds are not victimless crimes. He engaged in this massive amount of fraud, and it wasn't just a simple mistake, a slight oversight. The variations were wildly exaggerated, and the extent of the fraud was staggering.
Trump said the penalty against him would drive other businesses out of New York.
We'll appeal, we'll be successful, I think, because frankly, if we're not successful, New York State is going.
This just happened. We are looking at a specific moment in time where the legal machinery of New York State officially began the process of dismantling a former president's business empire. This is not a drill, and this is not political rhetoric. New York authorities have moved beyond warnings and have taken the initial concrete legal steps required to seize physical property from Donald Trump. We are talking about the registration of judgments in Westchester County and the explicit identification of skyscrapers in Manhattan. This represents the most severe internal rupture between a political leader and the state legal apparatus in modern American history. The stakes here are absolute. This is about the potential collapse of the Trump Organization and a constitutional stress test that pushes the boundaries of what the system can do to a candidate for the presidency. We are watching a collision between the image of a billionaire and the reality of court-ordered enforcement. The system has initiated a sequence that ends with padlocks on doors unless a massive amount of cash moves immediately. This is the situation right now.
President Donald Trump and his co-defendants to pay more than $350 million. The ruling also bars Trump from running any company in New York for 3 years. Judge Arthur Engoron released a decision 4 months after finding Trump had committed fraud by inflating his assets and net worth, all to get better terms on loans and insurance.
We need to look at exactly what is happening on the ground in New York because the details tell a very different story than the headlines. You may have seen reports or videos suggesting that federal marshals are currently at Trump Tower putting chains on the doors. That specific event has not happened yet. Marshals are not physically seizing buildings at this exact second. However, the legal reality is actually much more serious than those rumors. The paperwork and the authority to do exactly that have been established. The only thing currently stopping law enforcement from taking control of Donald Trump's signature properties is a bond and a legal appeal that is still pending. This is not a theoretical exercise. This is a loaded weapon sitting on the table of the New York Attorney General. To understand why this threat is real, we have to look at the ruling from Judge Arthur Engoron. This ruling was released in February 2024, and it was devastating. The court found that Donald Trump and his company engaged in fraud for years. The judge determined that they systematically lied about the value of their assets. They did this to get better loans from banks and cheaper insurance rates. This was not a small accounting error. The court found it was a massive intentional pattern of deception. Because of this, the judge ordered Trump to pay a penalty of roughly $355 million. But in the legal world, penalties come with interest. The interest on this judgment accrues at 9%. When you do the math, the total amount Trump owes climbed to roughly $454 million. That is nearly $500 million. That is not a fine you pay from a checking account. That is a number that threatens the existence of the business itself. The Attorney General of New York, Letitia James, went on television and made her intentions incredibly clear. She did not use vague language. She stated that if Trump does not have the funds to pay off the judgment, she will use enforcement mechanisms in court. She said explicitly that she will ask the judge to seize his assets. She then became very specific. She mentioned 40 Wall Street. This is a massive 72-story skyscraper in Lower Manhattan. She said she looks at that building every single day. That was a direct message. She was telling the world that she has already identified the targets. She knows which building she wants to take. She did not just say this on television. Her office took action. In March 2024, the Attorney General's office formally registered the civil fraud judgment in Westchester County. This is a critical technical detail that many people missed. Westchester County is just north of New York City. It is the location of the Seven Springs Estate and a Trump golf club. When you register a judgment in a specific county, you are legally preparing to seize assets in that county. You are creating a lien against the property. This is the necessary first step before you send in the sheriff or the marshals. By filing that paperwork, the state of New York moved from making threats to preparing for execution. Reuters described this as the precursor to asset seizure. Trump was forced to scramble. His lawyers told the court that he did not have the cash to pay the full $500 million immediately. They argued that he would have to sell properties at fire sale prices to come up with the money which would cause him irreparable harm. This was a moment where the curtain was pulled back. The man who projects an image of unlimited wealth was telling a court that he could not write the check. Eventually, a New York appeals court gave him a temporary lifeline. They agreed to pause the collection of the judgment if he posted a smaller bond. They set the number at $175 million. Trump posted that bond. He used a company called Knight Specialty Insurance to back it. Because that bond is in place, the Attorney General cannot send the marshals to 40 Wall Street or 7 Springs today. The enforcement is paused, but you have to understand that a pause is not a victory. The judgment still stands. The debt is still real. If Trump loses his appeal, he will owe the full amount. The bond is just a guarantee that the money will be there if he loses. If the appeal fails, and if he cannot pay the full $454 million, plus the new interest that piles up every day, the state goes back to the seizure plan. The mechanism for this is standard in the legal world, even if the target is a former president. If you owe a judgment and refuse to pay, the court issues a writ of execution. This order goes to the sheriff or the marshal. They go to the property, they levy the property, they sell the property at an auction. The money from the sale goes to the state to pay off the debt. This happens to normal people every day. Now, the machinery is pointed at the man running for the White House. This situation creates a massive contrast. On the campaign trail, the image is strength and success. In the courtroom, the reality is a desperate fight to keep the assets safe. The civil fraud case is not the only financial pressure he faces. He has legal fees from criminal cases. He has other judgments against him. When you add it all up, the pressure is unprecedented. The state has proven it can pierce the corporate veil. They have proven they can restrict his ability to do business in New York. The judge barred him from running a New York corporation for 3 years. This strikes at the heart of his identity as a businessman. The narrative that marshals are currently seizing buildings is false, but the narrative that the state is ready to seize buildings is true. The difference is just a matter of time and the outcome of an appeal. The Attorney General has done the homework. She has filed the papers in Westchester. She has eyed the building on Wall Street. The system is waiting for the final green light. If that light turns green, the process will be automatic and physical. It will not be a negotiation. It will be an eviction of ownership. This is the reality of the situation. The bond is the only wall holding back the flood. If that wall cracks, or if the appeal is lost, the assets are exposed. The state has shown it is willing to go all the way. We need to step back and analyze what this means for the structure of power in this country. This situation is significant because it represents a total failure of the fear that usually protects high-level political figures. In most political systems, and certainly in the history of America, there is an unwritten rule that you do not use the full weight of the commercial legal system to dismantle the personal empire of a former president. Usually these things are settled. They are handled with quiet fines or agreements behind closed doors. The system typically fears the instability that comes from trying to bankrupt a major political leader. That fear is gone. The actions of the New York Attorney General and the ruling of Judge Engoron show that the institutional hesitation has evaporated. When we compare this to history, we usually have to look at other countries to find a parallel this stark. We see this in nations where a new regime comes in and systematically uses the courts to strip the assets of the previous leadership. It is common in Eastern Europe or parts of South America. In America, however, we are seeing this play out through a civil fraud statute. This makes it unique. It is not a military coup seizing assets. It is a bureaucracy using math and property law. This is actually more dangerous for the target because it is harder to fight with political rhetoric. You can call a political attack fake, but you cannot call a lien on a property deed fake. It is a matter of public record. It is bureaucratic, slow, and incredibly difficult to stop once it starts. The core of this crisis is the exposure of vulnerability. Power is often about the perception of invincibility. For decades, the Trump brand has been built on the idea that he is untouchable and has resources that cannot be depleted. This legal process has done something that no political opponent could do. It forced him to admit a lack of liquidity. By making him scramble for a bond, the court system stripped away the mystery of his finances. It showed that even a billionaire has limits. This changes the psychological landscape. If the state can force a former president to ask an insurance company for help to save his buildings, the aura of total control is broken. We also have to analyze the specific choice of targets. The mention of 40 Wall Street is symbolic. That building is a landmark. It represents the height of American capitalism. By targeting that specific asset, the state is sending a message about who actually owns the system. The state is saying that property rights are conditional on following the rules of the state. If you violate the fraud statutes, the state can take the most prestigious symbol of your success. This is a reassertion of the power of the institution over the power of the individual. It is a reminder that in the American system, the court has the final word on who owns what. There is also the factor of the corporate death penalty. The restrictions on doing business in New York are just as significant as the money. New York is the financial capital of the world. Being banned from operating there is like being a fish banned from water. It forces a complete restructuring of the organization. This is not just a punishment for past actions, it is a dismantling of future capabilities. It weakens the apparatus that supports the political figure. This is why the crisis is existential. It attacks the supply lines, the money, the loans, the corporate structure that allow the political operation to function. Furthermore, the registration of the judgment in Westchester highlights the reach of this power. It shows that this is not contained to a courtroom in Manhattan. It follows the assets wherever they are. It creates a cloud over the title of every property. This freezes the assets. You cannot easily sell or borrow against a property that has a massive state judgment hanging over it. This creates a paralysis. The business cannot move, it cannot pivot, and it cannot generate new cash easily. This strangulation effect is often more damaging than the seizure itself because it bleeds the target dry over time. Finally, we must look at the precedent this sets. Regardless of how you feel about the target, this is a new era of legal warfare. We are seeing the civil court system being used as the primary battleground for high-stakes political conflict. The gloves are off. The norms that protected political figures from total financial ruin are gone. This means that in the future, the definition of political risk includes the risk of losing your home and your business. The line between political defeat and personal bankruptcy has been erased. This changes the calculation for anyone entering high-level politics. It raises the cost of the game to an absolute level. Looking at the short-term consequences, the immediate future is defined by the appeals process. This will not happen overnight. The legal system moves slowly, and this delay is the only thing currently protecting the properties. In the coming months, we will see a battle of paperwork. The Trump legal team will try to get the judgment reduced or thrown out. The attorneygeneral will fight to keep the full amount. During this time, the bond sits there as a placeholder. However, the danger is in the details. If the insurance company that backed the bond decides that the risk is too high, or if there are technical issues with the collateral, the protection could collapse. If that bond fails for any reason, the pause button is released and the seizure can begin immediately. We are walking a tightrope where one technical failure leads to Marshals at the door. In the long term, the outlook is fundamentally about the survival of the Trump organization as we know it. Even if the judgment is reduced, the financial hit is massive. The interest alone is millions of dollars. This drains liquidity that could be used for the campaign or for other business ventures. We are likely looking at a forced contraction of the business. Trump may have to sell assets voluntarily to pay the debt, which is essentially a seizure by another name. He will lose the trophies of his career to pay the state. This diminishes his standing in the real estate world and reduces his financial footprint. If the appeal fails completely, the consequences are stark. We will see the forced sale of iconic properties. This will be a public spectacle. The state will auction off buildings that bear his name. This will be a humiliation that is hard to recover from politically. It creates a narrative of defeat that is physical and visible. You can see the building being sold. It is not abstract. This could damage the winner persona that is central to his political appeal. We also have to consider the ripple effects. Banks are watching this. Lenders are watching this. When a client faces this kind of state pressure, they become toxic. It will be incredibly difficult for the organization to find new partners or new financing. The credit markets will close off. This leads to a slow suffocation of the business operations, The long-term consequence is that the Trump family may lose control of the empire they built regardless of the election outcome. Predicting what happens next, we can follow the logic of the legal system. The most likely scenario is a long, grinding war of attrition. The state will not back down because they have a judgment in hand. Trump will not back down because he cannot afford to lose. This means the case will likely go to the highest courts possible. However, because this is a state civil fraud case, the avenues to the American Supreme Court are limited. The reality is that the New York court system will likely have the final say. Ultimately, the math is the enemy here. The numbers are too big to ignore. Unless there is a massive infusion of cash from an outside source, the assets are the only way to satisfy the debt. The logic dictates that at some point property will change hands. Whether it is sold by Trump to pay the bill or seized by the sheriff to pay the bill, the result is the same: the transfer of wealth from the individual to the state. The era of operating without consequence is over. The bill has arrived, and the collection agency is the government of New York. This is the new reality, and it is moving forward day by day.